So let's get started. Welcome, everyone. It's great to have you all here at this 5P Council's webinar. This webinar is called AI Act, DMA, and SEP Regulation through the Better Regulation Framework of the Commission. My name is Axel Frazzini. I'm the Managing Director of 5P Council, and I will be your host today. As you know, and I'm sure that you know it, 5P Council is a not-for-profit research organization. We focus on the link between IP and innovation. Our mission is to identify the most relevant topics and produce empirical research by collaborating with a variety of academics, experts, IP organizations, and other stakeholders. On our website, you can find a lot of free materials. I mean, everything is on the website. So just start browsing, you will find a lot of things such as studies, summaries of relevant papers, recordings of our webinars, podcast interviews with inventors, entrepreneurs, and IP disseminators. We also produce easy to digest content, such as the SME Corner. So this corner is dedicated to SMEs. The goal is to make sure that you have all kinds of information tailored for non-IP experts and startups to discover all the benefits and roles of IPRs. We also have an area on our website called IoT and Cellular Standards Made Simple. This is a very important section of the website because we receive a lot of positive feedback. So you can learn about the benefits of standards and IoT across different sectors. Check it out. And if you have any comments, let us know. We have recently launched a new section, which is called the AI and intellectual property rights, with guides, videos, papers, interviews. The goal is just to help you to understand how AI is revolutionizing the way we live, work, and create, but also, the pressing questions raised about IPRs. But without further delay, it is my pleasure today to introduce our speakers. We have Dr. Natalia Menendez, Dr. Niccolò Galli, and Dr. Marco Botta. So let me just give you a short bio for each of the participants. So Natalia Menendez is a research associate on data governance at the Center for Digital Society of the European University Institute. She is also a visiting researcher at the Biometrics Law Lab of the Center for IT and IP Law at the KU Leuven Faculty of Law and Criminology. She is a co-founder of the DigiCon blog and a former vice chair of the PhD Students in AI Ethics Research Group. Niccolò Galli is a research associate at the European University Institute, Center for Digital Society, and contract professor of IP and Competition Law at the University of Florence. Previously, he was a scholarship holder at the Technology Transfer Offices of the University of Florence and the Tuscan region. Marco Botta is part-time professor at the European University Institute, where he is the coordinator of the Florence Competition Program and Entrance for Judges. In addition, he is affiliated research fellow at the Max Planck Institute for Innovation and Competition in Munich. Finally, he is adjunct professor at the Law Faculty of the University of Vienna, where he teaches EU, competition, and state aid law. A final remark before getting started. For all of you, you can see at the bottom of your screen a Q&A tool to submit your live questions. That's where you have to submit your questions. So please feel free to raise any questions during the presentation, which should last around 25 minutes, 30 minutes, and then we'll take live questions one by one. So that said, Natalia, the floor is yours.
Thank you very much, Axel, and also thank you to the 4IP Council team for organizing this webinar and allowing us to present this research. So basically, the raison d'être for the research, the reason why we thought this paper was necessary, I think I don't have to explain it in this forum, but the first and main reason was the proliferation of digital regulations. So basically, despite of the one in, one out policy of the European Commission, which is actually part of the better regulation framework and the withdrawal of the SEP's regulation proposals or the AI liability directive, we see new regulations coming to the table. For instance, this quite recent Digital Fairness Act as a non-stop. And what is more important is the interaction between these regulations. So the scope of these regulations in some cases is overlapping, and even some aspects are sometimes interacting or even contradicting themselves. So we can see here in the slides an example of a paper I co-wrote together with Marco Botta and Daniel Borges, where we analyze the concept of pseudonymized and anonymized data in the context of international data transfers across different regulations, such as the GDPR and the Data Act. And we saw actually in this paper that there are different conceptualization of this concept that sometimes contradict themselves and interact. On top of this, we have the Draghi report with this famous, I would say, claim that increasing regulation does not help innovation at all, and also discussing the issues of this proliferation of digital regulations that I mentioned before. So actually our starting point for this paper was maybe instead of focus on quantity of digital regulations and try to regulate everything and from all different aspects, it would be better to focus on the quality of those digital regulations. But actually, in order to examine the quality, we need a proper framework. So what we did in this paper was to choose the better regulation framework of the European Commission that dates back to 2015 and was updated in 2021 after, among many other reasons, after the COVID pandemic, because the pandemic put into question that the EU regulatory process was not up to the challenge posed by new technologies, by health diseases, and I would say modern society or current society. The better regulation framework is composed by a series of documents. The two most important on which we build for the paper are the guidelines and the toolbox. The guidelines basically outlines all the different aspects and steps that regulators need to take into account when they are proposing a new regulation. And the toolbox is a much more extensive document which I would say operationalizes into a lot of detail all the different steps, all the different operations that the regulator need to comply to in order to fulfill the demands of the better regulation toolbox. So the better regulation toolbox is actually a very detailed document with a lot of explanations. In a nutshell, what the better regulation guidelines establish is that the EU policymaking cycle is composed of 3 steps, so preparation, adoption, implementation, and application. And through all these steps, there are 2 crucial, let's say, moments: the impact assessment and the monitoring and evaluation phase. And another thing that the better regulation framework always emphasizes throughout the whole policymaking cycle is the participation of stakeholder input. So stakeholder input from both external and internal stakeholders is considered a crucial variable that needs to permeate throughout the regulatory process. And with this general framework in mind, in our paper, we analyzed 3 different regulations that Niccolò will explain in the next slide.
Thank you. Yes, so with this in mind, let me just stress also that the better regulation framework is a soft law instrument that is deemed not to be binding on the Commission in its preparatory work in proposing EU legal acts, but at the same time, due to the principle of legitimate expectations and good administration, we and as citizens, we expect the Commission to stick to it and to at least explain the reasons for any reasonable deviation from the framework. So with this in mind, the 3 pieces of EU regulation that we studied in the paper are the AI Act, the Digital Markets Act, and the proposal for the SEP regulation. So we started with the AI Act, which is considered the first international AI framework worldwide. It is essentially a consumer protection-like regulation, which imposes proportional obligations that are based on the risk of the AI system. It's also a very prominent representative of a regulation that affects a given type of technology per se and all the data-related activities that it involves. It's also a prominent attempt of the EU to safeguard fundamental rights and freedoms in the context of the emergence of the new technologies, especially the very high-risk AI systems. Then passing to the DMA. This is a market regulation, a regulation that in digital markets that is derived from the EU competition law experience, but also the telecom regulation experience. It's a regulation that has the goal of increasing fairness, so preventing exploitation, especially of business users of digital services, but also contestability, so lowering entry barriers in digital markets. Finally, the SEP Regulation Proposal, which has been provisionally withdrawn earlier this year, was an example of a new attempt to foster standard-related innovation directly through regulation. In essence, it was expected to create a sui generis IP regulatory framework for patents that are essential for the implementation of standards. However, I mean, it's very broad, overarching content created a spark debate and divided essentially the stakeholders affected by the regulation and also the political work. And so at the moment, it's very uncertain whether this regulation essentially in its proposed form will ever come through. So these three pieces of EU legal acts result all of the EU's will to regulate the digital economy, safeguard fundamental rights, protect competition, and foster innovation. They were all proposed during the first von der Leyen presidency and all relied on Article 114 of the Treaty on the Functioning of the EU as a legal basis. And this is the legal basis that allows the EU to adopt and harmonize member states' laws to remove barriers to the internal market. This is so despite actually more specific legal bases existed for each of the three of the two adopted regulation and also for the proposal for the SEP regulation. So also, let's say, focusing on the background and the expertise of Natalia, which as a data protection law researcher, Marco Botta as a competition law scholar, and me as a researcher on the patent and antitrust interface. I mean, we delved into the details of how the Commission came to this proposal for legal acts. And in the paper, you can find, let's say, a much more detailed analysis. But let's say for the interest of discussion, I will just focus on some prominent results that we found. So comparing the rules and the aims and principles of the better regulation framework to what was actually done by the Commission in the proposals of these pieces of legislation. And for example, starting from the first very important phase of the better regulation framework, which is the public consultation. So this is the phase where the Commission engages with stakeholders and seek their feedback on the problems faced by the stakeholders themselves and the possible solution. I mean, in one of the principles of the better regulation framework is that in consulting and in this participative effort, the Commission should explain and offer different policy options, not just, let's say, not just a single one or a predetermined one. So it should maintain its openness and transparent toward possible outcomes of its legislative effort. And we can see that, for example, in the case of the DMA, this was done. There was also the possibility for adopting a revised and more prompt competition law tool type of intervention besides the DMA, while for the AI Act and the SEP regulation proposal, actually, this was not really the case in some of the consultation. Also, another very important aspect of the public consultation phase is that the Commission should publish a so-called synopsis report, where it should explain why it chooses a given option and why it disregards or endorses the feedback received by given stakeholders. So somehow should be transparent on the motivation for undertaking a given policy route. And here, actually, the Commission has been quite consistent in not publishing this type of report for either the AI Act, DMA, and the SEP regulation proposal. Moving to a second phase of the better regulation framework, this is the impact assessment report, and here the Commission should really study well the cost and benefits, the impact, the economic impact of the possible policy options, and here an important result was concerning the fact that while in theory the report should address and compare different policy options, the Commission did not really compare actually options in every instance. So sticking to the SEP regulation proposal, I mean, there you can find not really alternative policy options, but actually complementary policy option constructed in an incremental way from the less intrusive to the most intrusive. And here, I mean, you can find that the first policy option was just to introduce soft law guidelines on FRAND administered by the UIPO Competence Center. Then passing to the second one, an SEP register with essentiality check with mandatory registration for enforcement purposes. Then a third, even more intrusive option would have been bilateral FRAND conciliation as mandatory pre-litigation step. Fourth and second last option, a FRAND royalty determination and also aggregate royalty determination. And finally, the most overextending policy option would have been to create an SEP clearinghouse, essentially transforming and trusting the UIPO to be a kind of a collective management organization for standard essential patents. And so here we can see that, of course, the options are construed in an incremental way from the less intrusive to the more intrusive. And of course, let's say it's easy to discard the most intrusive ones and go for the most reasonable ones among those proposed by the Commission. Here, I mean, the same impression we have it also for the DMA, where the DMA was put as the most reasonable option in between a very flexible, too much flexible regulatory intervention and then a very rigid regulatory intervention. Also, it's interesting that the policy option should be analyzed based on evidence, so quantitative data and scientific findings. And here, I mean, we understand that there might be a difficult task, but really the Commission just uses in every of these three instances the evidence in favor of the endorsed policy option and does not really deal with the rest of the evidence. Also, there is a review mechanism of the impact assessment by a separate European Commission body, which is called the Regulatory Scrutiny Board. And so the Regulatory Scrutiny Board is required to give an opinion on every impact assessment, so a positive or negative opinion. In the case of negative opinion, with some suggestion for improvement. And here, I mean, the Commission did not really always deal with the suggestion of this board. Finally, the explanatory memorandum phase. So this is the document that is attached to every proposal, and it's intended to summarize the work that has been done on the issue, on the legislative measure by the Commission. And for example, this memorandum, I mean, of course, is intended for policy, for MEPs, for politicians, so it does not have as extensive as the impact assessment, but at the same time, it should include a short summary of the input gathered from experts on the legislative proposal. For example, both for the AI Act and the SEP regulation, there is no such a summary. Also, the opinion of the Regulatory Scrutiny Board should be accounted for and explained in this memorandum. But again, in both the AI Act and the SEP regulation, this was not really, was just given at, accounted for at face value without going into the merits of the opinion. So, I mean, from this detailed analysis that you can find in the paper that 4IP Council has just published today on their website, we derived some conclusion that now Marco is going to give you in detail.
Thank you, Niccolò. Yes, indeed. Our idea was to analyze these three legislation that most of the people know, they are aware about them, not from the point of view of substance, let's say, which have been extensively discussed in the literature, but looking at the decision-making process followed specifically by the Commission and using the better regulation framework as a sort of benchmark to assess what the Commission has done. And I think the overall results of our analysis is that the Commission has been not consistent when it comes to following the better regulation framework. Remember that this is a framework that the Commission adopted by itself, let's say. It binds, it limits the Commission political discretion in elaborating a legislative proposal, but it was the Commission's own initiative. Of course, this is a non-binding instrument. It's a soft law document. So no, let's say, EU regulation or directive can be challenged at the Court of Justice because the Commission did not comply with these guidelines. But I think it's a sort of important finding that should lead to some kind of reflection inside of the Commission. So I can summarize a bit the main findings. I think many things have already been said by Niccolò. When it comes to the public consultation, probably the most serious non-compliance with the better regulation framework is the lack of publication of the this summary report of the public consultation, the synopsis report, where essentially the Commission would be required not only to publish what the stakeholders have said about the proposal, but also how the Commission did not take in consideration in the final proposal some suggestions from the stakeholders. So the requirement to publish a synopsis report is clearly mentioned in the better regulation framework, but this was not done by the Commission, neither for the AI Act, nor for the DMA, nor for the SEP regulation. Then when it comes to the impact assessment, as you know, the impact assessment is a document attached to every Commission legislative proposal where the Commission essentially should analyze the cost and benefits of the different policy options. This document is also reviewed by this Regulatory Scrutiny Board, which is an internal independent body within the Commission. And we found very interesting that both in the case of the AI Act and in the case of the DMA, the Regulatory Scrutiny Board rejected the initial impact assessment elaborated by the Commission. And in the case of the DMA, at the end, it was approved subject to some concerns on the side of the Regulatory Scrutiny Board. In both cases, I think the main issue is that the Commission carried out this cost-benefit analysis, let's say, selectively. Like in the case of the DMA, for instance, this was done only for the preferred policy options, which is what we have today. So a list of 20 obligations applicable only to the gatekeepers, which fulfill certain turnover threshold and other quantitative thresholds. While the other two policy options, which were included in the DMA impact assessment, which was a closed list of self-executing obligations for the gatekeepers and a so-called fully flexible options, similar to what we have today in the United Kingdom, where the Commission would negotiate with each gatekeeper specific obligations. These two options were just mentioned in the impact assessment, but the Commission did not make any type of cost-benefit analysis, let's say, for the different policy options. So to some extent, the impact assessment exercise becomes something like a predetermined results, where the Commission explains that the best option is what it has already in mind. Then when it comes to the explanatory memorandum, which is these documents that the Commission attaches to the legislative proposal, we also found some inconsistency when it comes to the draft SEP regulation and the AI Act. For instance, the summary of the opinion of the Regulatory Scrutiny Board was not included, and so on. But I would say that these were minor, let's say, cases of non-compliance on the side of the Commission. I would say the main problems were on the side of the public consultations and on the side of the impact assessment. So what we can do about it? So as I said, as Natalia explained before, the data regulation framework was adopted by the Commission before COVID pandemic. It's relatively new. It was, I would say, applied by the Commission in adopting all this new legislation, part of the overall EU digital acquis. It's clear that the Commission has not always been consistent in applying this framework. We also have to recognize that the Commission is the only EU institution which now complies with this framework. So the Council and the Parliament committed in 2016 in an interinstitutional agreement also to adopt a sort of internal better regulation framework, but they have not done it so far, at least. Also, several principles of the better regulation framework have not always been followed by the Commission. Well known is the one in, one out principle, where essentially a new regulation should be proposed by the Commission when a previous one, which is not needed anymore, is removed from the EU legislative frame. So this has not been followed consistently. What we propose in the paper is that we consider the better regulation framework an important framework in terms of policy making. The Commission should be more consistent, more compliant with its own framework. Why the better regulation framework is important? Because it allows policymakers to adopt legislation based on evidence, let's say, on clear evidence. And we see a difficulty in regulating the digital economy, the digital markets. It's a moving target, clearly, but I think the Commission should be a bit more consistent, a bit more careful in collecting evidence before coming out with a proposal. So I think we can conclude here. We thank you for your attention. We also thank Axel for this opportunity of collaboration between the 4IP Council and the UI Center for a Digital Society. And we look forward to hearing your questions and comments.
Thank you so much for all this insight. I mean, that's amazing when you compare different regulations and acts and how things have been followed or not totally followed. And I really enjoy reading your paper. So I just would like to remind that the paper is now on the website. You can all download it. You have an executive summary also available. And so now taking a few questions that have been posted here. Let's get started with the first one, which is, in your view, what are the one or two most significant deviations from the better regulation framework best practices observed across these three initiatives? And how might these inconsistencies undermine the stated goal of promoting targeted, effective, and minimally burdensome EU regulation?
Natalia, do
Maybe
you want to
Natalia or
reply?
Marco? Yeah, go ahead. Natalia, you're muted.
Okay, can you hear me now?
Yes, that's good. Thank you.
Okay, so to me, maybe the most important one could be because as I mentioned in the presentation before, stakeholder inputs were a crucial point over the full policymaking process. And despite of having some stakeholder consultations proposals across the three regulations, I don't think this was consistently used. And also the fact that the way the result of this consultation was not properly presented by the Commission to the citizens later. So for instance, as Marco mentioned, the lack of publication of certain reports does not make available to the people who contributed to the stakeholder consultation, and second, to every citizen who might be interested of reading or consulting the output of this consultation to access this data. And in a way, this, from my point of view, counteracts the purpose of having stakeholder consultations in the process. So I would say that would be the main deviation. Also, there are some other points that Marco mentioned. So even though it's true that maybe the explanatory memorandum would be less important than the impact assessment or the other two phases, I consider that, for instance, in the case of the SEP regulation or the AI Act, the fact that the reasons for the rejection by the Regulatory Scrutiny Board were not also provided. Again, it's a lack of transparency that stakeholders interested or just citizens could have direct access to this information.
Okay, very good. Next one is, what are the primary challenges or potential resistances the EU institutions might face in adopting a more harmonized, better lawmaking approach across the entire legislative cycle?
Yes, maybe I can take it. I think the main resistance, and we see it on the side of the Council and the Parliament, that so far they have not adopted a better regulation framework, is the perception of losing, let's say, the decision-making discretion, the political discretion in adopting, proposing and then adopting a specific legislation, let's say. But we don't consider this a good excuse, I would say, a good reasons, and we consider that legislation should be evidence-based and the better regulation framework works in this direction. I see, Axel, that there are also a lot of questions coming out in the Q&A sessions. I don't know if you want to select some of them.
I received many. So one thing first is, yes, the slides will be made available later today on the 4IP website with the recording of the webinar. So everything will be made available. So don't worry. Then there is very specific questions that are related to the SEP regulation. We can try to cover a few of them. So does it affect your assessment that the mandatory public consultation for impact assessment and legislative proposal was issued ex post, as was the case for the draft SEP regulation?
Yeah, this is mine, I would say. No, thank you, Agnieszka, for the question. I mean, I'm sure you remember. Actually, I mean, we had two public consultations before the proposal on SEPs. So we had a first consultation in 2022, and here actually the Commission gave some alternative options. So just first one, increasing transparency through public disclosure requirements and essentiality checks, which was what everyone expected since many years, since the essentiality checks pilot project Then, back then, the second option presented for this public consultation was guidance on front licensing. And here, I mean, this could have been something close to competition law guidance, such as the one that we have on technology pools in the technology transfer guidelines. And the third option back then in 2022 was to incentivize alternative dispute resolutions for SEPs. And this was the case before the public consultation, before the introduction of the proposal. Then we have the public consultation on the proposal itself, which, let's say, did not include other options except the proposed one. And instead, in the impact assessment, and perhaps I can go to the next question, Axel. I think it's related. So on the impact assessment, what do I mean when I say that the regulation as a step, the proposal for regulation as a step-by-step approach from less intrusive to more intrusive? And of course, Agnieszka, coming from Nokia, I guess it's you mean that, of course, if you have thousands of SCPs and then you have to register them to enforce them, I mean, this is quite burdensome. True, I mean, of course, it depends on the company, but the way that the impact assessment was construed was that each component, let's say, found the basis for the next component. So the 5 options, soft law guidelines by the UIPO, a SEP register with mandatory registration for enforcement purposes, bilateral frank conciliation as mandatory pre-litigation step, frank royalty determination and aggregate royalties, this SEP clearinghouse. I mean, these were not presented as alternatives, but were presented as complementary components, where the second option would always include the next option would always include the previous option. And so, of course, I mean, coming through the final option, the one of the essentially changing and entrusting the UIPO to be a collective management organization for SCPs, building on all the previous option, was the most intrusive in this sense.
Very interesting. Trying to go back to another one. How does the lack of documented rationale for major policy shifts impact stakeholders' willingness to participate in future consultations and their confidence in the transparency of the policymaking process? Who wants to answer this one?
Maybe I can jump in, because I think in a way it's also kind of related to my previous answer, because I think it impacts in the way that there's a lack of transparency in the process, which might discourage people to participate, because in the end, these public consultation processes, we at the Center for a Digital Society have submitted inputs in several of them, and it's a timely process that you put a certain effort on it, and then you want to also take something out of it, which is you want to see how they took into consideration or not what you propose, and how it affected the final regulation, if it did or not. And this lack of information and this lack of transparency, in a way, I guess I can't speak about myself, but I would say in general could affect the willingness of interested stakeholders in taking into account this part of the process or in participating.
Very good. A very general high-level question is, will the LETA report and the 2024 Competitiveness Council conclusions, such as systematically considering the cumulative impacts of new obligations, change the European Commission's approach? If so, how should it change the approach? Anyone having an answer to this one?
But I think this, as you said, it's a very high-level question which goes far beyond the scope of our paper, clearly. I think that our paper falls within this broader policy debate that is taking place in Brussels on how burdensome is the current regulatory framework when it comes to the digital sector in Europe, let's say. And to do in the paper is simply to say, let's say it's important for the Commission to comply with certain steps when it comes out with a new regulatory proposal, let's say. But I would not have a specific question to this very high level question, a specific answer to this very high level question.
Okay. Another one is how challenging is it to apply an evidence-based framework like the BRF to novel, rapidly evolving technologies such as AI? And what specific adaptations or foresight mechanisms might be needed for future regulations in such dynamic sectors?
Yes, this is a great question. Thanks a lot, Agnieszka. It's something that we were thinking a lot while writing this paper. This is clearly the main challenge that is faced by the Commission, even in following a better regulation framework. If there is no evidence available, let's say it's difficult to comply with this type of framework. Then what else can you do? I would say there is no single answer, there is no single way to go, let's say. It depends, as lawyer would say. One possibility clearly is to adopt first guidelines, general principle. That's what Agnieszka is suggesting, and then to see what is the reaction of the industry. And then in a second phase, eventually you regulate. But there are other tools. At the national level, for instance, there are a lot of regulations which have developed regulatory sandboxes, new approaches to regulation where essentially the companies are monitored, let's say, they operate in a sort of monitor environment, and then only afterwards, let's say the regulator comes out with binding rules after understanding better what are the problems and what are possible solutions that works. This started in the fintech sector many years ago. Now we have examples of regulatory sandboxes also in the data protection field and so on. It seems to me that the Commission is not following this type of approach yet. This could be an option. We don't discuss it in the paper, but let's say if we want to have a general discussion on how to regulate digital markets and digital economy, I think we should be a bit more flexible, let's say, in the approach followed by the Commission in this area.
Maybe if I can just jump in and add
Of course.
something, because this was something that actually happened during the regulatory process of the AI Act. So basically, at some point, the legislator said that they couldn't provide a lot of evidence because AI technologies were relatively new. There was not enough public available data, and so on and so forth. And actually, what the regulatory scrutiny board did not buy this argument. I think, in a way, thinking the same way as Marco mentioned now, that there were ways of gathering data. Actually, later the legislator organized different workshops with different stakeholders, and they were able to gather some data, and also that different, more flexible approaches could be used.
Okay. Next one is, how crucial is it for the European Union to strengthen its adherence to an evidence-based approach, as indicated in the BRF, not just for internal effectiveness, but also to ensure that its landmark digital legislations, like the AI Act and the DMA, set a credible and robust standard for global digital governance?
Natalia, do you want to go ahead or should I take it?
Yeah, I can maybe my 2 cents. I mean, the famous Brussels effect that it's usually commented and that started, let's say, with the GDPR. There was a big discussion about whether the AI Act will also have a similar effect on AI regulations all over the world. The fact that it was the first one at a certain level maybe gave it some effect worldwide speaking. But I would say it's slightly different. But it's true that adherence to these evidence-based frameworks, the more adherence there is, probably the better it would help to to have this kind of effects. In the case of the GDPR, for instance, it was like that. The GDPR, it's true that the legislative process was long, but it was very well documented. The reality at this moment with the processing of personal data was also a very hot topic and present all over Europe. So I would say the more evidence-based, also the more evidence you give other jurisdictions to adopt similar frameworks.
Any other answer, or we move to the next one? Okay. How does the Commission power to withdraw legislative proposals fit the better regulation framework?
I can chip in. The simple answer is that the right of withdrawal of the Commission is not considered at all by the better regulation framework. So the better regulation framework only cares about how the Commission comes up with a proposal, not regarding its withdrawal. It's also and this right of withdrawal is also considered a corollary, let's say, of the right of initiative of the Commission. And I mean, if we wanted to interpret it, let's say, in line with the acceptable and reasonable objectives and principles of the better regulation framework, I mean, first of all, we would need transparency and a statement of motivations. So, I mean, it's important that the Commission has this power, and it should also exercise it in line with the better regulation principles, even if not considered by the better regulation principles themselves.
Very good. There's one question that I don't really understand, but let's try to take it. How can a non-binding guidance document be binding on the European Commission?
No, thank you. I mean, it's as I mentioned in the presentation, I also invite to read the paper. There is reference to case law, to the Court of Justice case law on the topics. As I said, I mean, soft law is not binding towards third parties, but it's such as communication from the Commission, which are quite common, for example, in the competition law sphere. I mean, they are, let's say, self-binding the Commission itself due to common principles of the EU legal system, which is the principle of legitimate expectations and the principle of good administration. So in this sense, if the Commission commits to a certain framework, we as citizens expect that it adheres to it, also because, let's say, it committed to this framework in the interest of democracy. I mean, this is done also to show that actually the EU there is not a democratic deficit, and so the exercise of powers can actually be, at the EU level, can actually be influenced by the citizens, for example, through the public consultation process. And so, I mean, it's actually a good question. And at the same time, as a soft law instrument, I mean, the Commission can disregard and not adhere to it, but should provide reasons why it does not adhere to the same principle that it has advanced.
Okay. Would a more incremental, transparency-focused SEP measure, rather than a monetary and overreaching central registry via the EU IPO, have increased political feasibility and stakeholder alignment, in your opinion? I think that's for Niccolò.
I mean, this would have been perhaps let's say the sensible option from the very beginning. So I mean, you can read it in the paper. I mean, we go way back to the 2010s and to the first expert reports commissioned by the European Commission. And so, I mean, actually the Commission was, before introducing the proposal, was building quite a strong stakeholder engagement and also quite a strong trust and reputation for its work on SEPs. for example, on the standard essentiality checks, with a lot of expert studies went into the topic. And so somehow when the proposal came out, was not really expected, let's say, at least in this level, in this scope. And perhaps, I mean, not even the Commission, let's say, seemed so certain about the scope of the regulation. And in fact, it commissioned, after proposing the regulation itself, it even commissioned a study to determine ex post the scope of the hypothetical regulation that could have been adopted by the EU co-legislator. So in this sense, I mean, now with the withdrawal, which is, let's say, it's not permanent, it's not definitive until the early August, but I mean, once it becomes final and the Commission goes back to the drawing board as suggested by some member states, I mean, probably this more incremental approach, relying on the previous studies, could have much better chances in the EU legislation process.
Very interesting. And one last question for today, at least so far. How might the unitary patent system and the EU competition policy have interacted or conflicted with the SEP regulation proposal? And what does this reveal about coordination failures within the EU legal framework, in your opinion?
No, there's also, let's say, a good question also in light of the current status of provisional withdrawal of the proposal. I mean, the proposal of 2023 did not really consider the entry into force of the unitary patent system with the unified patent court and patent PMAC, patent mediation and arbitration center. So also the competence center at the UIPO would have somehow overlapped with certain competence and jurisdiction of the unified patent court, not even like being sure that the UPC, like any other judge, would have followed and adhere to the results of the procedures before the UIPO. So, I mean, this could also have risked in legal uncertainty and fragmenting the SEP regulatory framework. Moving to, let's say, to the competition law perspective, of course, I mean, what we know from the case law stemming from Huawei versus ZTE, I mean, is that we need a case-by-case approach because SCPs do not necessarily confer dominance, and there might be cases where, for example, injunctions are not abusive even by dominant patentees. And so, I mean, the requirement for registration of an SCP, I mean, would have somehow conflicted with this case-by-case approach endorsed by the Court of Justice. And also, the proposal did not really consider the ongoing revision of the technology transfer framework. So the framework that excludes, exempts certain types of patent licensing agreements and creates a safe harbor for patent pools. Patent pools were essentially regulated in the proposal with obligation to provide information regardless of their, let's say, their legal status under the guidelines, current guidelines that are being reformed by the Commission.
Well, okay, that's okay. I see another question that is interesting, but that's not really in the scope of the study. So I'm not sure if that would be good to take it, which is, what do you think about the recent draft of PMAC mentioning the SCPs?
No, so I mean, of course, I mean, this shows that the UPC as an existing institution that we arrived at after several years can play a role in the standard essential patent system. And I mean, now with the withdrawal, it's good that it can take this proactive role and so tailor some procedures, some alternative dispute resolution procedures to the specificities of SCP litigation. So I think it's a good effort. It's also non-binding to go through the PMAC, so it's an option, and I like options. I like competition. So one more option for dispute resolution, hopefully on a global level, not country by country. It's appreciated.
Thank you so much for sharing your knowledge. That's a fascinating topic. I mean, we can expect more regulation, more acts from the European Commission, and I hope that the recommendations that you are making in your research paper will be seen and taken into account. So that's the time where we have to conclude. I have to say that I learned a lot reading your research paper, and I can only encourage everyone today to download it, to review it, and if they have any questions, they can always get in touch directly with you and with our IP Council if they want to, and we will relay your messages. Thank you to all of you for attending this webinar. The recording, as I said, will be made available on the website tomorrow, the slides as well. And don't forget to follow us on X, LinkedIn, YouTube, Instagram. We have also a great podcast that you can listen while you will be on vacation, maybe if you take a break during this summer. We have maybe 43 episodes from little inventors, innovators, big companies, great stories to listen just while you might be on the beach. So if you want to know what will be the next webinars and any other deliverables we are about to publish, subscribe to our mailing list and you will receive everything. Finally, I would like to thank again Natalia, Marco, Niccolò, and I wish you all a great break and talk to you in September then. Thank you.